Ostroff. Jordan grew up in South Florida and came to Orlando to attend the University of Central Florida. He is the son of a postal employee and a substitute teacher. For whatever reason, he had always known he wanted to be a lawyer, even without knowing what that really meant. At UCF, he competed on the trial team and traveled around the country doing fake cases and learning real skills. He continued to Barry University School of Law and continued on his path to being a great trial attorney. After graduating law school with high honors and a litigation certificate, he went on to work for the state as an assistant state attorney. There, he handled thousands of cases and handled around 50 trials and hundreds of motions. Eventually, he left the state with a dream to do things a different way, to leverage the latest legal technology and systems to create client-focused practice. Jordan Law started in 2015 with just Jordan in a small office and has since grown to a multi-attorney firm and with its own building, taking cases throughout Central Florida. You will see that Jordan Law differs from the very first minute you call the office. Our whole firm is cloud-based. So those first questions our staff ask about your contact information will be saved every time. So you don't have to fill out the forms multiple times over. Little details like streaming the entire legal process and allowing us to give you FaceTime with your attorney rather than having one lawyer and 15 staff members. Jordan believes that high seas raise all boats, and to this day, we get over 90% of our cases from referrals, such as other lawyers, doctors, financial professionals, and especially current and former clients. That means that we've all built these systems and processes to not only do an amazing job on our cases legally, but that we have to make it as smooth of a process for the whole way through. We aren't looking to be your lawyer on this one case. We are looking to be a trusted partner in your life for the next 20 to 30 years. When he's not managing the office and building a better system, Jordan can usually be found either playing disc golf, eating with friends, or with his wife and son enjoying SeaWorld, the Science Center, or just digging in dirt with toy construction vehicles his son likes to play with too. So Jordan, happy to have you as our guest speaker. Normally, Mark Bryce does the bio and the introduction. He does a much better job than I, but I gave it my best. And we are so happy you're here. Please take it away.
All right, thank you so much for having us, for having me, and then Ed here as well. So just to tell you a little bit more about the firm as it relates to this. So we are a mostly business law firm. That is the backbone of the firm. And so during coronavirus, it's been very interesting because of everything changing so frequently, from a legal perspective, from a factual perspective, from a, who would have thought 5 years ago we'd have our key chair here in a mask out in public and whatnot. But this is the situation we find ourselves in. So I want to outline basically the balancing test that happens in a couple different situations when it comes to coronavirus. And so, for example, what do employers have to do to provide a safe workspace? So that's something that comes from federal law, that comes from OSHA. You have a duty to maintain a safe workspace. The issue here, though, is with coronavirus, everything changing so quickly, there aren't the same OSHA regulations or standards when it comes to coronavirus. So what we have advised people to do is follow the CDC guidelines, which also changes relatively frequently. But that's kind of where all of this starts. As an employer, you have a duty to provide a safe workplace. And so in this case, that would include trying to minimize the spread of COVID. So for example, when we're looking at the rights and responsibilities of everybody under this, in the state of Florida, employees really don't have rights. So an employee has the right to not be fired based upon any sort of immutable class, race, sexual orientation, etc. But in Florida, we are an at-will state, so you can fire somebody for no reason. You just can't have it be a protected reason. So what COVID did is COVID went in and under the Family First Act, Family First Leave Act, which came out just before the CARES Act, it provided a requirement on employers to allow paid leave to employees. Now, normally this is relatively similar to FMLA, but this applied to employers of much smaller sizes that had previously been impacted. And so what you have now is you cannot terminate somebody because they have coronavirus, because they think they had coronavirus, because they might have been exposed to coronavirus, because they have to stay home and care for somebody and don't have the opportunity to telework. And so now really in the state of Florida for the first time, we have all these other things that we have to balance when it comes to being able to get rid of staff members or employees. So this has put a lot of extra rights on employees to be protected in the situation that we're currently in, and has put a lot more responsibilities on employers. And so a lot of what we're talking here is balancing OSHA regulations with the Family Leave Act and federal law with Florida state law. So if any of you are outside of Florida or advising clients for any reason outside of Florida, it may be different. There are other states that are not at-will work states. There are other states where somebody can't be fired for no reason. There has to be some sort of reason along those lines. So as we get into, what do you do as an employer? The first step I think is following the OSHA guidelines. And I know for those of you in Orlando, Orange County, I think has done a really good job. They put together some extra relief plans or grants for companies that will pledge to it, and then they outline what that means. And so in Orange County, they were giving a grant of up to $10,000 for businesses that would comply with this based upon if you got a PPP loan or for the amount and whatnot along those lines. But things like having your employees stay 6 feet apart, wearing masks in the office, having temperature checks for everybody who comes into the office, moving obviously as much as you can remotely as possible. I mean, those are some of the basic things that'll change a little bit as we learn more about this. Hopefully we'll have a vaccine soon. Hopefully we'll have a little bit better of an understanding of this virus. But what we're seeing here really is the scientific method on something that would take 10 or 15 years being crammed into 6 months, as we learn how this impacts people. So the most common questions that we get are, you reopen the office as the employer, you have an employee that refuses to come back to the workplace. What can you do? And that's where we go back to that balancing test. So from the standpoint of as long as they don't qualify under the Family Leave Act, the Family First Leave Act, you can fire that employee. You can terminate them for them refusing to come back to work. The problem becomes if they're not coming back because they may have been exposed to coronavirus, if they're not coming back because they have to care for a child who is doing virtual school or something along those lines, if they have to stay home to care for a loved one that's impacted by coronavirus more seriously, then you can't get rid of them under that federal law. So for the most part, you can order an employee back to the office or terminate them, except in those limited circumstances based upon why. The flip side to that is what happens if you have an employee who contracts COVID and they do want to come back to work. So here, I think we're pretty set with OSHA, that's not a safe workplace. If you are aware that you have an employee who is tested positive for coronavirus, do not let them back into the office. That is a pretty simple one. At the same time, you can't terminate them. So it becomes a situation where, what do you do from that perspective? And it may be a case where, you have them work from home, you give them the opportunity to telework, something along those lines. The next step about this, though, is what happens. So and that one I think is pretty clear. But what happens one step back? You have an employee who may have tested positive. What do you do in those circumstances? So now we're bringing in a totally different federal law for HIPAA, which deals with the ability to have privacy when it comes to healthcare issues. So if you send an email to your staff that says, hey, John Doe has tested positive or maybe come in contact with somebody who had coronavirus, I think you all should go get tested. Now you have violated John Doe's HIPAA rules and you may be liable from that standpoint. So it puts employers in a really tough spot The easiest thing is, we talk to employers about saying you may have been in contact with somebody who had it, or you were in contact with somebody who's tested positive. It's our position that you should go get tested immediately. Hopefully at this point, everybody has the opportunity to, for the most part, work from home. So you can order the employees to work from home for the most part along those lines. And obviously, anybody who does come into the office, if you've got an office of 10 people and 9 of you show up for work the next day, it's pretty clear who came in contact or tested positive. But you're not violating the HIPAA requirement by not disclosing the person, even if everybody obviously will know who it is. We had an example of a client who literally has one employee, or sorry, has 2 employees, and they ended up having one of them test positive, and so they had to do the explanation to the other employee that they may have come into contact with somebody when there were only 2 employees. But by doing it that way, they stayed in line with the HIPAA requirements. So by the same token, you can mandate employees to wear masks. Obviously, that goes back to the OSHA running a safe workspace, and that's basically what it stands like from the employer perspective. So if you have somebody who may have tested positive, I think you have a duty to let the rest of your office know. I can't tell you there's definitively a law that says it. I just think that's what the OSHA requirement is going to require, but you can't disclose the HIPAA. From the employee perspective, I think you have a similar argument here where if you come in contact, I think you have a duty to stay home. That's the issue of why I think they passed the Family First Leave Act is because that employee doesn't show up, they don't want to get fired. So by letting the employer know, you're giving almost kind of safe harbor to the employee that they're going to get some protection. Hey, I can't come in because of this situation. Now, what the government did on that perspective is they gave employers the opportunity to get some tax credits and tax relief for those employees who are going to get paid and are not able to work along those lines. The one thing, though, that I will say, so everything we're talking about here is from the standpoint of minimizing exposure, minimizing liability, right? The problem or the solution, depending upon what side you're on, it's going to be probably impossible to figure out where you contracted COVID from. You're not going to be able to say that, well, just because, John Doe has it and Sally gets it the next day, we can't really legally prove that Sally got it from John. With almost any virus, also with mold, with things like that, it's really hard to prove liability, especially for COVID having a very long incubation period. And I think this is something we saw for any of you that are NBA fans like me. Literally, I think the first part of this was 2 Utah Jazz players testing positive for COVID. One of them, a couple of days before, had been intentionally touching everything in front of him and then tested positive. It upset the other player, but then, the explanation was it's just as likely you gave it to him as it is that he gave it to you. So that's going to minimize the ability for any of these things to become an actual case. And again, I say that positive or negatively, depending upon what side you're on. So there's going to be probably quite a bit of protection on employers if, God forbid, one of your employees gets it and gets seriously injured or something along those lines. It's going to be really hard for them to put that back on you. But from the employee perspective, it's going to be just as hard to recover from getting COVID from an employer. So what we've seen is some of the different government agencies over here mandated people to have to come back to work regardless of tests, regardless of where they were at, under some of the emergency requirements that they had. If any of those people unfortunately got COVID and died, it would be a very difficult case for their family to go forward and prove that it was from the employer. So everything that I'm saying here from an employer perspective, balance it with, even if you really mess this up, it's going to be a pretty difficult court case to go ahead and prove it. And from the flip side, as an employee, just know that even if you do everything you're supposed to do, it's going to be really hard for a lawyer to prove that your employer is the reason you got COVID and any injuries that came from it. So that's a lot to digest in a pretty short time. Again, I would say following OSHA standards, following CDC guidelines, a really good place to start. If you're going to potentially terminate somebody during this time, I would reach out to a business attorney that I would talk about the situation. I would try to have a conversation with the employee. At the end of the day, an employer and employee having a heart-to-heart conversation, makes things a lot easier, makes people a lot less aggravated, makes people a lot less likely to file a lawsuit. And so that's, those are the things to balance right now. And just to backtrack for 1 second, so I talk about the injury part being difficult from the standpoint of proving with COVID. Obviously, from a employment lawsuit, you don't really have an injury. The injury would be losing your job due to whatever the COVID reason is. So you might see a lot more cases that would normally be injury cases, be employment discrimination or violation of the Family First Leave Act. So it is extra important to discuss with an attorney prior to terminating an employee, unless the business is going under. I mean, like if flat out, if unfortunately you're in that situation, like what I think every restaurant is unfortunately in right now, having to terminate a bunch of your staff, there really is no opportunity. What we're talking about here is for employers that are going to survive this, that may come out of it a little bit smaller or, something along those lines. These are the things that we have to balance, and it's tough and it's complicated and it's changing every week, every month, the CDC guidelines are changing pretty frequently. For us, the court system is different by county. There's 3 different phases. Orange County is going to move into phase 2 ASAP. That changes everything in regards to how we can handle our cases and what cases can actually happen in court. So, all of us, just to the extent that you can use a little bit of grace and have that really good conversation with people, that's a great place to start to minimize any potential legal exposure. And then obviously, if you do know that push is going to come to shove, talk to an attorney beforehand. That might be a $1,000 or $2,000 conversation. That might prevent a $50,000 or $100,000 problem if you've got especially a high-level employee that's going to be terminated that may end up claiming there's some sort of coronavirus issue. That can be very, very expensive when all this is said and done. So with that, I'd like to open it up for questions because obviously so much of this is fact specific. I don't know how we want to do that, John. I can juggle if I go pick up some balls. I can kill some time that way. So,
if anybody has a question, they can unmute themselves.
You never know. If nobody has a question, either you're the best speaker or the worst speaker. And it's always one of those two.
Jordan, a question for you. My name is Richard Blaylock. So since things are changing all the time, if there were to be some sort of a legal question, is it driven by what was in place? How do you decide which periods, guidelines, or rules are relevant? The current ones, the ones that were in place for 3 weeks when it happened, the ones that were in place for 2 months before that. Is there any easy way to think through that?
For the most part, you're going to be governed by what was in place at the time the incident happened. So if that's somebody contracting it, you're going to go by that date. If that's somebody getting fired, you're going to go by that date. The other thing is we're definitely going to see some litigation happen after this for like business interruption insurance and whatnot. So what you may see some sort of federal rule or guideline that requires the use of a specific thing or use of a specific law or a specific timeline or an override of an employment contract in some respects. If that's the case, you're going to be at the mercy of that decision. But 99% of the time we're going by at the moment that the case became potentially viable. So the termination, the contraction of the virus, unfortunately, a lot of cases, the death or incapacitation of somebody due to it. That's the unfortunate reality of this. That's going to be the timeline that'll judge.
And then one quick follow-up question. What's your estimation on how sort of the pertinent laws and regulations will be different in the long term after this? Not just during this, but where's it going to settle in, do you think?
So from my perspective, unfortunately or unfortunately, I don't see us having long-term federal or nationwide employee rights coming out of this. I just don't see that happening. I think we'll see more emergency situations come up along those lines. I think where you're going to see the biggest change is going to be with insurance companies, how business interruption insurance, how they protect things, workers' compensation insurance. I think the insurance companies are going to be the ones that'll push a lot more change than we'll get from the legislature out of this, because ultimately they're the ones, protecting everybody or backing from a financial standpoint. And I think a lot of them are going to take a bath on business interruption insurance long term, because normally it's built for requiring some sort of physical injury or damage to property. So especially in our area, hurricanes, over in Brevard, a lot of our clients have that stuff. It's not really designed for forced shutdown, act of God, riots and looting. I mean, we've been through quite a last couple 6 months. So I think that's where we'll see the most things. So that's why I think we might see some sort of federal determination that insurance policies, unless they specifically eliminate viruses or non-structural damage from the policy, that they're going to have to go ahead and pay out, or at least have some sort of discussion. But the flip side of that is, business interruption policy is supposed to go into effect really quickly. It's supposed to be there to get you through that hurricane in the next, 3 weeks, 4 weeks, 6 weeks. If we're talking about 2 to 3 years of litigation to get through some of these claims for business interruption over 6 months, or over even just mandatory shutdown times, a lot of businesses, unfortunately, are just not going to be able to overcome not having the money. I did see somebody ask, employer obligations on COVID prevention. So I'll jump on that from Dominic. Thank you so much for that question. So that's where, we go back to, you have a duty under OSHA to have a safe workplace. And so for the most part, that's going to be following CDC guidelines. So what I've seen a lot of businesses do is they've rotated staff. So if you can't be in a situation where you've got staff more than 6 feet apart, if you've got cubicles, if you've got the bullpen, what some people have done is they'll have half the staff in the office, Monday, Wednesday, Friday 1 week, and Tuesday, Thursday the next. They'll rotate through that, or they'll have certain positions that will go fully remote during this to minimize the amount of foot traffic through there. There are no real, at least in Florida for us, there are no really hard and fast employer requirements for preventing the spread of COVID. That's why I went back to, I really liked what Orange County did, where they offered a grant to companies from their share of the CARES Act if they did make that pledge to follow the CDC guidelines, and it outlined 8 or 10 things along those lines. So best practice would be have as many people out of the office working virtually as you can. And then those that are in the office, mandating masks, keeping people more than 6 feet apart. We bought one of those non-touch temperature things. So at $30-50 online. So anytime anybody comes in our office, they get their forehead swiped like a barcode. It's kind of, assuming that it works correct, it's really creepy that you can take somebody's temperature from that far away with the laser. But that's, some of the things that we've done. We've got the benefit of, we're in one of the Dr. Phillips houses that's 100 years old. So everybody is in their own room when, to the extent that people are in the office. Not every office is going to have that opportunity. My prior offices definitely would not have had that. So we have it lined up where everybody is in essence, their own room. Otherwise, and we have some people still working, 100% work from home to make sure we can keep that going. So those are some of the things that we've done. Those are some of the things that I would advise people to do. And then the only additional one is just to go back to that HIPAA requirement. If you do know somebody gets it, please, please, please let your office know without letting them know specifically who got it, because that's where I think you're going to see the issue is employers knowing that somebody had COVID and ordering them back into the office, and then having somebody else get it. As difficult as that might be to prove from a legal standpoint, I think a jury would be very happy to side with the employee who got COVID because their employer didn't send the sick person home.
Jordan, what advice would you give a business owner who has customers, and some customers strongly do not want to wear a mask, but it's your company policy because, let's say, for example, it's a hair salon and employees are coming and, it's a close contact type of business. What advice would you give to the business owner that he or she could communicate to a customer who is very angry and yelling and screaming about not wanting to wear a mask?
So I'm going to answer this question two ways. I'm going to answer it as a lawyer, and I'm going to answer it as a marketer the second time. So in one respect, I mean, you should, from a lawyer perspective, you should be protecting your employees at the expense of customers. So that is mandate the mask, talk to them about the mask, politely tell them to leave, potentially call the police and trespass them from the mask. The only issue that you're going to have, and we're recording this, so I won't curse, but there are a number of people that have come up with some sort of stupid, like fake badge that says, you know, like my religion doesn't allow me to wear a mask or something along those lines. That is bogus, except to the extent that you may have an Americans with Disabilities, an ADA potential lawsuit. If you have somebody that has a genuine medical condition that has a specific asthma, something along those lines, doctor's note to not wear a mask, you may have to accommodate them. The problem is you open yourself up for like just as much liability the other way. And that's why I kind of always go back to that, have that heart to heart, tell people, you know, be open and honest with them and try to be understanding with everybody to minimize some of that aggravation. From a marketer standpoint, I mean, I don't know if you guys have seen it. I've seen videos of the, you know, owner of the business going and screaming at the employee or screaming at the customer and like pulling them out by the scruff of their neck. And that gets 5 million views, and that business has record months because everybody wants to go support that upstanding business owner that was protecting their employees. So I did not answer it that way as a lawyer, but from a marketing perspective, from a business owner perspective, you know, go for it. At the same time, here in Orlando, we had 33 and Melt, which was having don't wear a mask in violation of all of it, parties, rallies, whatever, ended up making nationwide news on either the Daily Show or one of those for the rally about a bunch of people not wanting to wear their masks. So whether that was long-term helpful or detrimental to business, I don't know, but it certainly got them quite a bit of publicity, taking what I would consider to be the wrong approach based upon usually advising my clients to follow the law. Charlotte asked, who can bring OSHA into the office if there is a problem, company or only the workers? So I don't know the benefit of a company bringing OSHA in because OSHA is really only going to come in to potentially fine the company. So that would be something where the workers would have probably just calling from the workers' compensation flyer that has the information for OSHA. That's probably where that's going to come up with OSHA being involved. If there's a situation where as the company perspective, you're not sure about the best way to do something, you may be able to get a hold of somebody at OSHA to ask for guidance. I doubt it. I think every government agency is normally overworked, and they're that much more overworked during all of this, plus having people work from home and whatnot. So I don't know why a company would want to get OSHA involved because there's really no potential benefit for them.
My background with OSHA is in the schools, and I was told that only the teachers could bring OSHA in. And so that's what I was wondering if things had changed. I mean, I've been out of the school system for a while. My children are older.
It would be really interesting, like in that situation, if students saw potential issues and contacted OSHA or something along those lines. I would think for the most part in that perspective, there'd be a more local government agency or even potentially like a sheriff's or police agency that would come in to enforce, like in Orange County, to enforce local mask ordinances or whatnot for those violations. That might get you a faster result.
This involved mold in the school.
Gotcha. Okay. Yeah, I mean, it's interesting because mold is the closest legal thing that we've had in the past to COVID. Like we have had viruses before, obviously, but not in the same manner, not in the same care, not in the same interest, and not in the same deadly amount. So mold is the most, when I talk to people about what to do, most of the time we're using mold stuff as the basis for coronavirus. Any other questions?
Any guidance for companies just from a due diligence perspective to demonstrate or provide evidence that they're following these the CDC procedures?
So the two lawyer answers of all time are it depends, or what I'm going to give you for this one, Stuart, get it in writing. So, you know, I would put together a COVID procedure. I would make sure it's emailed to everybody. If people are in the office, have them sign it, something along those lines. If you've got a large enough office where you've got a safety manager, or if you're working with, you know, an industry that's going to have an OSHA rep internally already, I would have them do trainings on this, just like any other safety procedure and what to do and whatnot along those lines. And I would document the heck out of those things. Dominique asks, how difficult is it to prove someone got corona at work? I think it's impossible, you know, or I shouldn't say, I think it would be very, 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 very difficult. And so that's why I go back to, you know, I don't know how many lawsuits you're going to find against businesses because somebody got COVID because of the difficulty to prove it. But at the same time, I think you're going to be hard pressed to find a juror or a jury panel that doesn't have at least one person on it who was impacted, lost somebody, lost a job, knows somebody who did. So if it is something that gets lined up in the right set of circumstances where somebody, you know, can swear up and down that they were living their life in a bubble except being forced to go to work, and they've got a better case, I would be very scared to go to trial as the employer. I would be hesitant to take the case on the employee side, but if we did make it all the way to trial, I would be very scared to be the employer.
Jordan, another question. What about sort of the indirect ramifications of working from home, either emotional, whatever it might be, that might be more difficult? I don't know, more difficult may not be the right word, but might be difficult to understand if the employer is really responsible for that, but displacing employers from the office, having them work at home, even if they don't get sick, but have other negative repercussions from that, whether it be mental health, emotional health, physical health, or whatever. Can you give us any insights into kind of how far the employer's sort of responsibility might extend away from the office in that kind of situation?
So for the most part, from a responsibility standpoint, you're not going to have any. You know, there's nothing that requires the employer to provide, you know, if they work from home, to provide some sort of mental health treatment or training or whatever it is along those lines. The flip side to that, though, is if you can do it, I would suggest do it. You know, I think a happy workforce works harder, works better, cares more, puts in the effort, doesn't sue you, talks to clients nicer, you know, pushes your business farther than they would otherwise. And so I think that's one of those where, you know, I wouldn't advise to share it with everybody, but I think if you had an employee reach out to you and just say, hey, look, I'm having difficulty working from home, these are the issues, I would advise the employer to make the steps that they can to go ahead and accommodate that. And at the same time, I think a lot of businesses are going to find that they're going to save a ton of money from work from home overall and be able to attract better clients as you get more and more people getting in that flow. And so there may be a situation where a business saves $5,000 a month on rent or reimbursing people for gas or tolls or whatever it is along those lines, that they may be able to spin off into something where, you know, they can do some, I don't know if it's telemedicine for psychologists as well, but some sort of some opportunity like that ends up costing them way less than they're saving from having most of the staff not in the office.
All right, thanks. And offering that is in no way implying that you're taking responsibility. You're just you're just doing the good thing. You're trying to help your employees out or assist them during the challenging times or make available resources to them, that kind of thing, right? That's not an implication of any kind of responsibility or for that.
So from a legal perspective, there's really nothing that requires you to do it. So it'd be, you know, if you had a situation where you forced people to go to, you know, I've been watching Hannibal, it's on Netflix, about Hannibal Lecter. Like if you force somebody to go to him and you like turn one of your employees into a serial killer, then obviously like there may be some sort of liability from there, but you offering, some benefit to your employees, something that's more realistic, there would be potentially some sort of circumstance where it would blow up in your face. It would be so hard to come up with that situation. I mean, if you've got insurance for the employees, it's probably covered in there, or at least the providers are in there. If you don't have it, it's something you add. I would pick a couple, pick 3 or 5 different groups or psychiatrists, psychologists, whatever it is along those lines. You really have to be in a situation where somebody got in touch with a psychiatrist, got put on certain meds, you ordered them into work, they got into an accident driving into work or something along those lines from the meds. I mean, it would be possible, but it would be very difficult. I think you're going to see 99.9999% of the time it would be a positive if you had an employee that came to you with that issue and you addressed it versus having the negative.
So Jordan, that was incredible, definitely timely. And I know there's probably other questions that people, because we're all human, so 2 minutes from now, we're going to come up with another thought or question, and we'll say, oh, I wish I would have asked this. So when we do that, are you okay if I share your contact information to the group?
Yeah.
Or to send that out, email, phone number, and then they can reach you directly?
Sure. So I'll type it and I'll give it to you all. So my email is jordan@jordanlawfl.com. FL is in Florida. And our phone number is 407-906-5529. 407-906-5529. And I promise you, one, I don't want you all to make a mistake. Slightly less, but very slightly less than you don't want to make a mistake. But two, a couple $100, a couple $1,000 on something that may end up being a 6-figure problem would be well worth it, especially during these trying times where businesses are really scratching and clawing to stay afloat, to not have to fire people, to keep things going the way that they've been going. I think you're going to see a lot more people that don't have anything to lose, especially when evictions become a thing again, especially if people don't bounce back from, at one point, the 30-something million people that have lost their job. A lot of people are not going to have an opportunity except to try to sue their former employer. So just keep that in mind, but also keep in mind the understanding of the position that employee is being put in, because I think that'll have you make all of your interactions with them as best as possible to minimize that being the potential long-term outcome.
All right, that is great. Jordan, thank you very much. And